The bottom line is, are we at war in your view as a nation?
Senator, all I know is that there are a lot of young men and women out there in harm's way so that we may sit here and have this conversation.
It would be news to them we're not at war.
I'm sure that's right.
Yeah, it'd be news to the families who've lost a loved one in this fight. So I think we're at war. Would you agree with me it's not a traditional war?
Certainly not, Senator.
There is no capital to conquer, no Air Force to shoot down, and no Navy to sink. There is no taking of Berlin and Japan. Do you agree with me it would be hard to determine when the war is actually over?
Senator, that was a question that the court struggled with in the Hamdi case, as you know.
And we had a lot of conversations about how to proceed forward when you were in the Bush administration. Is that correct? And you were in the camp of the Youngstown Steel camp, that if Congress is involved, the president is stronger, not weaker. Is that right?
That's right, Senator.
But there are some authorities that the president's commander-in-chief have that cannot be taken away by the Congress. They're inherent to the job. Is that true also?
There's certainly people who believe that, Senator.
Well, I am one of them. But having said that, because you can't have 535 commander-in-chiefs, Senator McCain and myself were trying to pass legislation that basically codified the practices of the Bush administration post-waterboarding. Is that a fair summary of the conflict?
Yes, Senator, I believe it is.
There were people in the Bush administration who did not want to go down the road that waterboarding was torture. That was not the view of Senator McCain or myself. At the end of the day, the Detainee Treatment Act codified how we treat enemy combatants in a time of war in terms of what practices we can employ in terms of interrogation standards. Is that correct?
Yes.
And it also tried to come up with a system of judicial review. I was in the camp that were at war, and in past wars, you don't give enemy prisoners lawyers. I don't remember any German or Japanese prisoner having a lawyer when they were captured. So traditionally, is it the commander-in-chief's job to determine who the enemy force is?
There's certainly legal authority suggesting that, Senator.
And this court's job to determine if the procedures in question pass muster? That's correct, Senator. Of course, this body plays a role, too. So the dilemma was that I believed it was the Department of Defense, the commander-in-chief's job to determine the enemy force because that's their expertise. And Congress could regulate the naval and land forces, and we had a say about how they could do that. And the courts have a say as to whether or not the procedures used by the President of Congress pass constitutional muster. Is that the general layout of this situation? That's the separation of powers at work. And there was a cross-current here. There was an email that you weren't part of. You were not included on the email, but it says, Neil and I have just been told separately, this is not what the White House wants. We have been given authorization to engage on the Graham Amendment, and not just authorization. They want us to engage, to eliminate if possible, but if not, to fix. DOD, not DOJ, has the lead, which may be what led to DOJ-LA's confusion. But the key point for us is that we have green light to engage on Graham. And what I was trying to do was preserve the Combat Status Review Tribunal concept, the ARB, Administrative Review Board concept, and allow the courts to judge the work product at the D.C. Circuit Court of Appeals, to have judicial review, but let the CSRT go first. Do you remember that debate? I do. Okay. And it was settled in the Congress where the Combat Status Review Tribunal would have the first shot at determining whether somebody's an enemy combatant, and the D.C. Circuit Court of Appeals could review their work product to see if it was capricious or arbitrary, if it made sense. The Supreme Court in Boumediene struck that down, saying it was not an adequate substitute for habeas. Is that correct? That's absolutely correct, Senator. And your role in all this was try to find out a way to engage Congress, Detainee Treatment Act, because it was your view that Congress being involved would strengthen the president's hand?
As a lawyer,
Yes.
I was not a policymaker, but I did advise.
As a lawyer?
As did many others. There were many other very fine lawyers, too, Senator, who advised the administration that engaging Congress would be a good idea because we had read our Youngstown and our Justice Jackson.
Any lawyer, I think, who understands this area of the law would suggest the president's stronger when he has congressional support. The signing statement. Is it fair to say there was a conflict between the vice president's office and other parts of the Bush administration about what this signing statement should say or look like?
That's my recollection, and that's about all I can recall.
I remember it very well because Vice President Cheney's signing statement was going to be, we have an inherent authority to do whatever we think we need to do. And there were a lot of other people saying, no, you don't have the authority just to set aside a law. You have to have a reason to object to it. So I just want the public to understand that when it comes to this man, I've seen him in action in very complicated emotional matters where he had one group of people who could give a damn about the terrorist and another group of people that wanted to criminalize what I thought was a real-world fight. And we tried to find that middle ground. And in a 5-4 decision, the Supreme Court struck down my proposal, and we fixed it later with a huge bipartisan vote so that every enemy combatant today has a habeas proceeding where the government has to prove by preponderance of the evidence you're in fact an enemy combatant. Then if they reach that conclusion, you can be held under the law of war as long as you're a threat to our nation. Is that a fair summary of where we're at?
That's my understanding, Senator. Along the way, your legislation did prevail in the D.C. Circuit and in the Supreme Court. Of course, it was a close call. It was 5-4, as I recall.
And that just proves that 5 people can be wrong. So, while I disagree, I certainly respect the court's decision.
You're not going to get me to commit on that one.